Sounds like a deal.
Dad, how many loan deals have you done in your career? Percentage
Thousands
wise.
and thousands, more than I can count.
Percentage wise, how many do you think you've done?
Percentage of the total closings?
Yeah.
Oh, that's a good one. 40% of our total closings, which, yeah, I never kept track of the number, but it's somewhere over 30,000 closings.
I think that's right. And it's also one of the challenges, don't you think, that if your business is maybe 30% of them being loan closings, you're not as good at them, as compared to maybe an attorney that's doing them 95% or not or 99% of the time. Um, that's the big challenge in this market, honestly, because it's not just us. It's all the realtors, it's the buyers, it's the sellers. We're not used to a ton of loan deals. We're just not.
Well, most don't know what other options there are, all the different types of loans. I mean, we deal with a lot of Fannie Mae, Freddie Mac stuff, so we should know those documents cold, which we do. But, whether you should refi with the same lender or not, whether you should just get a line of credit on your house up north or an equity line against your portfolio. Those are all things that I've done over the last 40 years,
Yeah,
guys
and so I
up and
think our
down.
job in this market, and I'll rope all people on this call into the same bucket. Number one, this is not something that a lot of realtors are familiar with, not something that a lot of attorneys are familiar with in this market.
Right.
Um, but we're going to guide you. And when you have a buyer that wants to do a loan or needs to do a loan, or if you're a seller and the buyer's making an offer with a loan contingency or trying to understand that, that's what this video is about. We got to make sure that we understand it. How do we evaluate it? What are all the different loan options? And whether this is a good deal or not. What at the end of the day, Dad, what does it mean to the seller when a buyer is getting a loan? What does that mean to the seller?
They have to, regardless of whether or not you have a financing contingency, let's say it's just a cash contract, they still have to let the appraiser in the house.
Yep.
And from a practical perspective, if will the guy have the cash to close? I mean, because you want to close the property,
Seller
but
wants to be paid. That's the
you
key,
want to
right?
get paid, you want the money, there's time value money. You might need it for another purchase or for some other thing. So regardless of what the contract says, nobody wants the unpleasant surprise that their buyer doesn't have enough money to close. And it kind of reflects anything bad happens, reflects on the realtors. So you really need to know this stuff.
Yeah, absolutely. And so when we look at deals, if you got two offers, one of them was a cash offer or no contingency offer, and the other one had a financing contingency. Does right off the bat, does that matter? It matters slightly because it's one extra contingency where the buyer might have to terminate and they would get their deposit back, right? At the end of the day, that's the main difference between the two.
From my perspective, I go
This would be
right
from
to,
the seller, right? From the seller first.
yeah,
That's
from the seller first. The cash with a nice big deposit and a quick closing is the dream, hopefully. Less issues to fight over. Having a financing contingency, that it makes it a maybe.
yeah, so it's more of a sure thing, but not necessarily a sure thing that the seller will notice. It could be a sure thing on the deposit. It could be a sure thing elsewhere. But at the end of the day, the seller gets the same money, and you can't ignore the final price. Like, would you take a 20% price reduction just to get an all cash offer that closes in 2 weeks? Probably
I've
not.
seen that happen. It's very rare. The one time I can remember off the top of my head, it was right before the first Iraq War, and it was a Port Royal property. The owners were from Germany, and our buyer, it was listed for 6 million. Our buyer offered 4 million closed in 3 days cash with a big deposit, and they took it because they were afraid of what the hell was happening in Iraq.
Yeah,
So,
so that
so
that
that
they're basically taking the sure thing, close in a couple of days, versus the unknown of 30 days from now, what could
yeah,
happen? Could the buyer lose their job? Could they get denied for the loan and now I'm back on the market in a scenario where the house isn't worth as much?
You get an emotional seller, that move can work. I mean, 'cause
If you have an emotional seller, my side of that is honestly, they're not that big
everybody,
of a difference. I'd rather wait. I'd take the higher price, wait the 30 days, and if it doesn't work out and the property's worth 20% less, well, I was selling for 20% less anyways. What's the big deal? What are we missing?
sure, you're in it for the long run, and
I'm
you do
trying to
this for,
maximize the money. Yeah,
yeah, but you
absolutely.
also do this for a living, so you
No,
look
but
at.
I want seller to if I'm the seller, I want to just maximize the profits, the income, right? So to me, at the end of the day,
Yeah,
don't overthink a financing contingency. All it is it's explaining to a seller how they're going to be paying for this. I'm going to go get a loan. Here's the rate. Here's who I'm going to be working with. And if I get denied, then I need to be able to get out of the deal. That's all it is. And you should know pretty quickly. It's a 2, 3, 4 week process. Don't, maybe you can limit the exposure that the seller has in that period. But at the end of the day, and I like saying in the end of the day, but ultimately, the seller needs to weigh the risk of a contingency with the benefit of the purchase price. That's the calculation.
if I'm the seller, I also want to know who's doing the loan, because if it's some
Yes, very
company they
relevant.
found on the internet that isn't familiar with this market down here, they don't know enough to write to the associations. They don't know which communities are on the approved list, and they're not going to return your phone calls.
Yeah,
Always, they're not going to return the realtor's phone calls. They're not going to
yeah,
return the attorney's
yep,
phone
totally
calls.
agree. And that's where this information is important. Context is key. So this is a NABOR standard sales contract, my least favorite contract. Although actually, Dad, I think the FAR standard contract is my least favorite. But of the two NABORs is my least favorite. It's the standard NABOR contract. So you've got your cash deal without contingency. I thought this was interesting. In other contracts I've read and written, they don't really spell this out. This is what they say: buyer will pay cash, but may obtain a loan for the purchase of the property. That's not a necessary phrase that has to be in there. That
No,
was to avoid the sellers getting angry when the buyer ultimately got a mortgage. At the end ultimately, I keep saying it that ultimately the buyer has every right to get a mortgage no matter what. They have a right to get a loan from a HELOC, from a brokerage account, from whatever, from
you're
mom and
right.
dad money. Um, so you can't control what a buyer is going to do, but you can control whether the buyer has the right to get out of the deal if it falls through. That's
Yeah,
what
this,
this
this this clause deals strictly with the safety of the buyer's deposit.
strictly the safety of the buyer's deposit. And so that's where our job starts, is even if they check this box, as a listing agent, we have to be very careful not to say the buyer is paying cash, because they may not be. Say, look, they don't want a mortgage contingency on this. I don't know where they're paying, but I'll ask. And that's where proof of funds would come in. So
Yeah,
proof of funds, Dad, what would you typically see for proof of funds?
email from a bank saying the client has sufficient funds to purchase
Yeah.
the property.
Yeah, other options might be a bank statement, or I've even seen where they write a letter saying the buyer has access to a line of credit up to, and then they put the purchase price or something
Yeah,
like
it
that.
could be a letter from UBS or Fidelity or somebody like that saying they have more than ample funds to buy it. I mean,
Yep,
that's
exactly. So that's our first step. Even if they check the box for cash, we probably need to verify where that's coming from. Is it a line of credit? Is it cash? Is it brokerage like stock funds? Is it in a 401k or an IRA? That's somewhat relevant. It's not very telling. It could be one of those things and be a problem. It could be something else and be a problem. But it's important to know that, because what we're trying to do is we're trying to empower the seller to make the right decision. Do I choose contract A or do I choose contract B? And so you could have a cash deal and they list a mortgage amount on line 36, proceeds of mortgage. It's a little confusing because it's like, well, you push cash, but it shows that you're getting a mortgage. As a buyer's agent, that is how I would do it because I want to disclose to the seller how I'm getting the money. There's nothing in the contract that requires a seller to, or requires a buyer to give proof of funds. But if I
No,
saw this, I'd want to ask, hey, you put cash, but it looks like you might be obtaining a mortgage. Who are you working with? Is that true? Is it a home equity line for your home in Illinois?
yeah.
Is it is it a hard money loan? Where's this coming from?
Proof of funds makes your offer look more attractive. It makes it look more certain. What I see a mistake in quite a bit is paragraphs 1 and 4 of this contract. 4 has all the terms of the loan except for the amount.
Yeah, let's go to
Amount
that.
is line 36 and 35 in paragraph 1. So I'll have zero or nothing under mortgage in paragraph 1, and then you'll have a financing contingency that doesn't tell you the amount of the loan.
Yeah, and that is a problem. So let's look at that part. So this, if you instead wanted to protect the buyer's deposit during this loan process, you check
Right,
box B, line 60,
right.
where it specifies that the buyer is going to obtain a loan as shown in 1B above. That is up here,
Yes,
proceeds of
the
mortgage.
amount.
You
That's
actually
the
have to
amount.
fill this out.
Yeah,
If
otherwise you
you
don't
don't,
know what
if you
size loan.
don't fill it out, it's a problem, right, Deb?
It's a huge problem. I mean, we don't know if it's an 80% loan, a 90% loan, or
Yeah.
a 50%
Yeah.
loan.
Yeah.
Uh,
So I actually had this deal come up recently. We were able to get the majority of the buyer's money back. So what happened is they left 1B blank. They did not put anything there. They filled out everything else in section 4B. The terms of the loan, the interest rate, all that stuff. But as part of the offer, they included a pre-approval letter with the amount. And so my argument, because I represented the buyer, was, you know, you were aware of this. Yes, we messed up. I'm sorry. We should have put that in line 1B, but the seller was on notice that we were applying for an 80% loan or 96.5% FHA loan. It was in the pre-approval. You got updates every week. No one objected to
yeah.
it. It's almost like you're stopped from making that argument. Maybe. I don't know.
Well, I mean, if there's a big deposit, I have been on the side of the seller and I've argued that there is no financing contingency because there is no meeting of the minds and that the amount is a material term. By the way, different paragraphs in this contract are severable. So if there's a flaw with a paragraph, this contract
Unless
allows
it's
you to just
material.
cross it out.
What if it's material, though?
So the
I
question
like this. I don't want you on the other side of my deals. I negotiated money to come back to the buyer. It was great.
but if you have 100 grand as your deposit and
Yeah.
average deal
Yeah.
is $1 million, are you going to really roll the dice and go to court, 2 sets of attorney's fees and the
Oh,
100 grand over this?
I didn't like this. I think the lesson I learned from this was fill out 1B the amount. That is so
A
important.
huge, I mean, and for people who are doing this part time or they're new to the business, I see it a lot. I mean, I really do. I mean, over the
Yeah.
last 40 years,
And
that's
and the
a
rest of
lot.
it is equally as important. So the other things you'll put on is whether there's like the interest rate. Is it an initial interest rate? Maybe it's a 5-1 arm or a 7-1 arm. What are we actually applying for? And this is where the lender is going to be vital. What kind of loan are you applying for? So initial would be if the buyer's trying to get a loan that's an arm or an adjustable rate. Or is it fixed rate, not
Yeah,
exceeding a certain percentage? And that's typically what we'll see. We'll see them putting, interest rates right now they're right below 7% on a
yeah.
conventional 30-year mortgage. So what I would like to do in this is I'd check box for fixed and I'd put 7% a year. And this is if I'm representing the buyer. Maybe I even put 6.91, which I think is the current rate. As a seller or as a listing agent, I kind of want this number to be as high as possible. I want if rates skyrocket to seven and
Right.
a half percent in the next 2 weeks, I don't want the buyer to be able to get out of the deal. I want their deposit to still be on the line because they can still get a loan at 7.5 if I put 7.5 here.
Well, the seller will want prevailing, and that's one of my pet peeves. I mean, if the whole point of this is to protect the deposit and you're on the buyer's side, put the number that this buyer has budgeted for. I mean, otherwise you're not doing your job in
Not
protecting,
doing your job in that scenario.
especially first-time home buyers. I mean, they got every little nickel budgeted,
Yeah.
and I've seen this quite a bit with these unethical lenders, where the client doesn't know until they get to the closing table what the interest rate is, and they're stunned.
Yeah.
And I feel like they're being taken advantage of, but there's not a thing I can do because we're at the closing table.
Yeah.
It's too late.
Yeah, unfortunately.
Yeah.
But luckily with the Frank Dodd Act or Dodd-Frank Act, they've kind of fixed some of that disclosure issue. So buyers have to be disclosed 3 days in advance of the closing. And on that closing disclosure, it shows them what the interest rates are. So they can't be sabotaged at the closing unless they put a no financing contingency. Then the buyer's kind of stuck. Do I lose my deposit? Do I lose my loan? Where do I push
Or
and
if it's
pull?
prevailing and they're just trusting their lender on what that means.
Yeah, so that's you keep saying prevailing. I see some people they'll put MKT for market rate.
Yeah.
Uh, the form doesn't really allow you to do that. It just has a percentage.
It just has
So
a percentage. Farbar has prevailing as the default, I
I
believe.
think, yeah, I think what if I'm the buyer's agent, we put something as close to what the buyer expects to get as humanly possible. If it's at 6.91 right now, I'm either putting that or I'm putting 7%. What if the buyer put 6.5% dead? What would happen there?
Well, anything up to 6.5%, if he
They
gets
could
the loan for
terminate,
that.
right? Yeah, so
If
that
it, yeah.
anything below 6.5, if you put 6.5 on this form, the buyer has kind of like free right to terminate the whole time because they're never going to get a 6.5. They're going to get denied because they could only get them a 6.91 or they could only get them a 7.1. So the buyer would have the right, if they wanted, to terminate. So obviously, you want it super low for a buyer. The listing agent wants it as high as we can or not at all. But there should be a balance. Honestly, this should be communicated. It should match what the pre-approval says, and it should be fair. If the buyer is saying, look, I've budgeted up to a 7.25 rate, if that's the reality, then that's what they've got to put on here, and the seller has to accept that risk. That
It
if
has
it's over
to be
7,
doable. Otherwise, we're wasting our time. There's
has to
so
be
much time, the
doable.
buyer's time, our time, the realtor's time. Um,
So the
you want
next
it to
part
work.
here, Dad, is the term. 30 years is the standard. That's a 30-year amortization.
Right.
Doesn't mean a buyer has to do a 30-year loan. They could always
No.
do 15. But if you instead wanted the 15 and you got denied because there's like a debt to income issue, this wouldn't protect the buyer because they're only protected on a 30-year mortgage.
Now, there's case law in this, Christian, that if you don't apply for the loan that's in the contract, you don't have the rights given to you in the contract. If you go
Yeah.
for something that's more, it's better, that's more difficult to get, you can't
Yeah.
invoke this clause.
And to that point, Dad, the thing that I see a lot of people make the mistake on is if they got denied because they didn't sell their other property, but they didn't make a sale contingency a part of their contract.
Yeah.
That is a huge problem. And I've had some dust-ups with other attorneys over this because you have to include it in your contract if you then need that as a contingency. If
What
that's
I
a
see a
challenge.
lot, what I've seen a lot over the years is the lack of a good faith effort. You get a buyer, they find something else they like better. They're looking for a way out of this first contract, and they're working with some close friend who's the lender, and they get a turn down letter, and the turn down letter doesn't comply with what's in paragraph 4.
Yeah.
Yeah,
Yep.
you can almost
Exactly.
smell, they failed to supply all the documents requested. Something like that might be the
Yeah,
cause.
and we can usually sniff that stuff out. The key here is be honest. You can't lie. You just
Make a good
cannot
faith
lie.
effort.
Good faith effort. The next thing on here, Dad, is buyer shall make the loan application not later than blank days after the effective date, and it's 5 by default.
Right,
Where this gets tricky is if a buyer is shopping rates. So they don't apply within the first 5 days because they're trying to decide, do I use Rocket Mortgage or Cogent Bank or SunTrust, or which is now Truist?
right.
They're trying to play the corners. They could get themselves in some trouble if they later get denied by one of those lenders because they waited till day 10 to actually make the application. So if you need to make this a little bigger to protect your buyer, from a seller's perspective, you kind of want this as tight as possible. 5 days is tight. I would say that's a really good number to keep a buyer honest about applying on time.
What drives me nuts, Christian, is we don't have time is of the essence in this contract except for the closing date. So, you get a weekend involved here and they apply on day 6 or day 7. Now you and I have to argue like crazy with some difficult lawyer on the other side.
Yeah, and that's not fun. We don't like that.
Yeah.
Communication is key. If everyone's on the same page, hey, like when you do this deal originally, you're putting it together, and the listing agent says, "Who are you going to use?" And you say, "Well, I've talked to both of these lenders. I'm not sure which one. I'll know by Monday." You say something like that, it's in writing. For the listing agent and seller to then make a huge deal out of not applying by earlier than Monday is kind of ridiculous. So communication, communication, communication. This part is wildly different, and we're going to talk about it when we compare it with FAR/BAR. If buyer fails to waive this contingency on or before they put a date, by
Yeah.
default, it's 45. Either seller or buyer may terminate this contract at any time. Couple of questions for you, Dad. If you don't waive it, what happens?
Nothing.
Nothing. The buyer still has their contingency. The
There's no break.
seller is still under contract. The only thing that changes is that now the seller might have the ability to terminate if the seller doesn't waive
They
it.
terminate and sell to somebody else if it's a seller's market. That's
If it's a
typically,
seller's market, yeah. So when we were going through COVID, there weren't a lot of homes that had financing contingencies. But if you did, we saw this, and especially coming into like 2022 and a little bit 2023, you saw where the sellers are like, why haven't they waived this? And you
well,
say, well, they don't have to.
and sometimes you get blowback from the rest of the family that why are you selling the condo, Daddy? And they change their minds. So I mean, I
Yeah.
got that quite a bit. So um, nothing happens, but if you're the buyer, and the way I explain it to the buyers is you're gambling the contract versus your deposit. If you waive, which one means more to you? Keeping this deal together? If so, then waive the financing contingency. If you're more worried about losing your deposit, don't.
So this gets a little tricky here, and so this is how I'll try to guide you through it. A
Hmm.
seller can terminate if the buyer doesn't waive their financing contingency. We go through this whole 45-day
Right.
period. Day 46, the buyer's like, well, I don't know yet, and I haven't gotten 100% approval from the lender, and the seller's like, well, I got a better offer, or I want to stay, I don't want to keep it. In the NABOR contract, what our advice is that the seller has to give notice to the buyer that they plan to terminate
Yes.
before they can actually terminate. And that's based on what you said earlier, which is that time is not of the essence. So we have to make it time of the essence first. So we
Yeah.
send a letter or send an email saying, if you don't waive the contingency by tomorrow morning or end of day, we reserve the right to terminate per section 4B. That's what we recommend for a seller. They don't need to do anything else. They would then send a letter or email saying, we hereby terminate. Now, question, who gets the deposit? Because it doesn't actually say who gets the deposit.
Whoever the parties agree.
Well,
I
based
generally
on
report.
this, if the seller terminates and the buyer never waived their
Oh,
financing
it goes back
contingency,
to the buyer. It
goes back to the buyer. So this is a contention that comes up, I don't know, maybe once a month.
Yeah, it
When
does.
a buyer doesn't see it spelled out. It doesn't say anywhere. It simply says terminate this contract at any time. It doesn't say who gets the deposit, but that's how contingencies work. If you have a contingency, whether it's inspection related, finance related, or something else, if that contingency, comes to life, if it becomes the reason the contract terminates, buyer will receive their deposit back. That is just how it works. If you needed to, you could add that into other terms and contingencies. If the finance contingency is, or if the contract is terminated, buyer would receive its deposit back per the terms of the finance contingency. You could do
I've
that.
done
You
that
don't
a
have
bunch
to
of times, mainly to appease,
appease a buyer. Yeah, exactly. We also like to just put that in the email, say this is how it works. It just
I
is.
want to be clear.
Yeah. Now, a buyer has the right to terminate as well, right? So they're protected under their finance contingency. They get denied for the loan. They can terminate, but the buyer has additional requirements. They don't necessarily have to give a heads up to the seller, the way the seller did to the buyer. But they do have to include a statement of adverse credit action from their lender, uh, that the terms set forth in this contract was denied on the grounds that either the property was unacceptable. How would a property be unacceptable?
This is where you and I disagree a little bit.
I was trying to set you up.
Yeah, I know you were
This
because
is a
I've heard you on this
setup. Come
before.
on. The property was unacceptable. What's that
Well,
mean?
okay, you have Fiddler's Creek where the developer still owns part of the common elements, so that would be
Yeah,
unacceptable with a Fannie Mae Freddie Mac loan. So I dodged it.
you
Blah.
did dodge it. Well done. So the lender says, hey, look, we can't do the loan in Fiddler's Creek because of this condition. And
Yes.
by the way, we've done a lot of loans in Fiddler's Creek. This shouldn't be an issue, but because of this condition, we've denied this loan. It's not because of anything that the buyer has done themselves. So that would be one way. Let's
You're
see,
thinking
property is
appraisal, right?
unacceptable, or the buyer financially failed to qualify for said financing terms. And that would be what we're more used to, at least nationally. The buyer's credit rating was bad, their debt to income ratio failed the test. They, didn't have something that the lender required to meet the Fannie
Insufficient
Mae
funds to
framework.
close.
They didn't have, yeah, well, even sufficient funds is not usually a reason to get terminated. It's
Do
usually
you
debt
still
to
get
income or
the
credit.
form, Christian, where they just check off the block? Because that's what typically I would see.
Yeah, and the interesting thing about those denial letters, it is a standardized form, but not all those boxes are applicable to this contract.
No.
So you have to be careful. And usually when deals fall apart in our office, Dad, the realtors will call us, the buyer will call us, the seller will call us, and we'll go through it together. If it smells fishy, we can usually tease that out. Now, this to full disclosure to you guys, my side of this is the buyer, that's one thing. They get denied because they don't have the income. But another reason that a buyer could get denied is if it doesn't appraise. The property did not appraise for the value that the lender was requiring per the loan terms. Dad kind of disagrees with that because he thinks you need to have an appraisal contingency or appraisal addendum in addition to this.
No, I
Um,
don't. I don't think that, Christian.
it's
Where
just
you
not clear, right?
it's not clear, but where you and I think, and correct me if I'm wrong, disagree, is that if you have $1 million contract subject to a $500,000 loan, if the property appraises at 800
Oh, okay.
instead of a million, I think the buyer is still up the creek.
Yeah,
You disagree.
I do. Yeah. So that's actually good. I'm glad you kind of made that distinction. So in Dad, in your scenario, the buyer wants a 50% loan, $500,000 on $1 million purchase.
Right,
So they're not asking for the maximum, they want just half. And so if the buyer's appraisal comes in at 900,000,
right.
well, the lender would still be willing to give them the $500,000 loan because it's
Plenty of equity.
still within Fannie Mae, Freddie Mac guidelines.
Right.
The lender has no problems. They don't even care about the appraisal. In fact, in that scenario, a lot of times the lender won't even require an appraisal. So how could it be the reason that the buyer gets denied? I think to me, it's a lot more black and white, but luckily we've never actually had to fight this out, between the two of us at least.
No,
And my
I've had it
point,
come
if
up
the
a lot.
property doesn't appraise, the property doesn't appraise, right? The terms
Yeah.
of the loan, I, I don't know. It's a
If
good
you want
one.
to be safe that it appraises at a million using our example, then use the appraisal addendum
If
because
you want to be
that
super
is
safe on that, yeah, exactly.
this just says it has to be a property condition
Yeah.
and appraisals and the way I explain it to my clients, and they teach it in real estate school. It's an art. It's not a science. It's not an exact number. So if you're within 10% or so, I tell my buyers you're good. I mean, depending on how long they're going to hold the property. If they're going to live there for the rest of their lives, then who cares?
Yeah.
Uh,
Yeah,
they're very
exactly.
inexact, and I use my own house. I've had appraisals on the house that were just so far off; it was ridiculous.
Yeah.
So
Appraisals are this mix of subjective and objective, so it's really
yes,
tricky. And a lot of times what it feels is it almost feels disingenuous, which is tough. If you've got a buyer that could still get the loan, but they're terminating because it didn't appraise, it's like, that wasn't really what we agreed to. That's where the seller gets upset and communication starts to fall apart. The other
Plus, the lender hires the appraiser, and there's got to be some indirect pressure to keep it low.
Well,
They
you
want to
can
make sure the buyer
certainly
in the game.
fear that. That's for sure. They tend, depending on the type of loan. Again, if it's a Fannie Mae, Freddie Mac, the lender has certain requirements in
Yeah.
that regard. But the other reason that a buyer could terminate and get their deposit back, and this one's really tough. Let me re-share this. Other evidence from the creditor lender that the buyer has made the loan application, made diligent good faith efforts to read all the requirements, but has received neither loan approval nor loan denial. Honestly, I've never seen that be used on a NABOR contract because, well, I guess we will see it eventually, but I just haven't seen it where you could say, I'm terminating because I neither got the approval nor the denial, and my contingency is still in effect,
Yeah,
even
I
though I
was always
really
able to get an
tried.
extension in this situation. I never actually had it blow up the deal.
Yeah, I don't think I've ever seen that. I don't know how that would play out, but it's interesting. Seller's right to terminate shall cease to exist if buyer waives this contingency, but prior to seller giving buyer notice of termination. So simply an email saying we waive our financing contingency. If buyer waives this contingency and is unable to close on the closing date due to a delay caused solely by the lender, due to some compliance and accommodate receipt and execution of a loan package and loan funding. Actually, I skipped a line. Buyer may extend the closing date up to 10 days for CFPB rule compliance. So if we're waiting for the closing date and the lender's like, oh gosh, I screwed up the disclosure, we need to redisclose and it's going to be a 3-day delay. The buyer has the right to extend in that scenario, even if they've terminated or waived their financing contingency.
Mhm.
Buyer acknowledges that once buyer waives the contingency, buyer's deposit monies are no longer refundable under paragraph 4. Makes sense to me. Makes sense to me. Now, the other one on here, before we jump to the FAR bar, would be the seller financing. There's a separate addendum for seller financing. And
Right.
it's wonderful. So you check this box, you would still put it in 1B, the amount of seller, actually it might be 1C. Let me double check that. I think there's a separate section for seller financing. Yeah, there is.
There is. Yeah.
So proceeds of seller mortgage would be here. So in 37, you would put in a seller financing. Maybe the seller's offering to give the buyer a loan for 6 months, almost as a bridge, at which point, and all the terms of that loan will be in the seller financing addendum. There is another addendum for FHA and VA loans. So if you instead chose that this is an FHA or VA loan, and I don't even think, yeah, it actually has a little highlight here that I want to point out. Line 63, if VA or FHA, the addendum of sales contract shall be attached hereto and made part hereof. So as a little guide, if you're getting a VA loan, if you're getting FHA, there's more information, there are more disclosures. FHA and VA loans have a lot more protections for a buyer potentially. The contingencies don't really expire, they just keep going. So you do have to have that separate form on there. That one's fun. Do you
Not
like
the
these loans now?
I hate to say it.
So I got a question here. I was told by an appraiser after the fact that his appraisal was on the low side because someone wanted it to match the previous appraisal and not create waves. The buyer had to change lenders mid-close and the first appraisal couldn't be used for some reason. Yeah, that's messy. I don't like that. There are guidelines in place to keep appraisers and lenders separate from each other. Now, that being said, appraisers, they have a license. They have certain guidelines and training that they have to follow. They have an ethical duty to follow. And if you feel like an appraiser is being unethical, you can actually report them to the board. And the board for Florida, DBPR, they take this incredibly seriously. Appraisers can lose their license for kind of blurring these lines. Now, separately, it does happen where an appraiser will change their report. So, like I was saying earlier, appraisals are a little bit subjective and a little bit objective. And so could you be 5,000 higher? Could you be 10,000 higher? Could you be 5,000 lower without upsetting the apple cart? Probably. You have to have the data to make that argument. but it has to be above board. So if you're a listing agent, even if you're a buyer's agent and it doesn't appraise, don't ever be afraid to reach out to the appraiser and ask him how, where the wiggle room was. Hey, we needed it this. Why isn't it there? What about this other comp? Sometimes, they're human. Sometimes they miss it. They just miss it.
What I've seen is that the appraiser might have missed a more relevant comp, or there might have been something about one of the comps that they didn't realize that would affect the ultimate valuation.
Yeah, absolutely. It's tricky. In my experience, most appraisers are just trying to do the right thing.
Yeah.
They're not trying to play games. They do know what the sales price is. The lenders do tell them what the sales price is. So they kind of know what their goal is, and they tend not to ever go above that amount. So that might sound a little fishy to you, but it's what happens. They know what the goal is, and they have to find all the data to see if it matches that purchase price or not. And so when appraisers come in low, they know what they're doing. They're doing it on purpose. They realize this puts us in flux, but it might be for nefarious reasons. I hope not. I don't see a lot of that, but I'm sure it happens.
It is odd that you never see an appraisal. I mean, I don't know if I ever have that's more than the purchase price.
Well, they do that on purpose because the appraiser doesn't want to put themselves at a much higher number for no reason.
Right.
And they have the number. All right, so this is FAR, Dad, our next favorite.
This
So on this
paragraph
one,
8, I think. I forget.
pretty similar here. You've got your line 39 financing
Right.
expressed as a dollar amount or percentage. See paragraph 8. So you do have to still put where the money's coming from. Again, from the seller, it doesn't matter where the money is coming from at the end of the day. Once you get to closing, the seller gets paid the same amount no matter what. In fact, I've got a question. Yeah, someone said they've seen appraisals higher. I see them higher as well. It doesn't mean anything. It
Okay.
doesn't mean that the buyer has automatic equity. It doesn't mean anything. It just means that the appraiser, I don't know, put too many zeros. Who knows? Maybe they felt strongly that it should be higher. Maybe they were trained to do it that way. But 98% of the time, you see them dead on with the purchase price. So, Dad, the FAR contract is very different when it comes to the financing contingency. In a nutshell, what's the biggest difference?
The ability, I would say, of the seller and realtor to be kept apprised of the progress of the application. I mean, I really like
There you
that.
go. That is nice. I thought NABOR had something like that as well, but
No,
I think the biggest difference is that it's a hard deadline.
it's a hard deadline. Time is of the essence for everything, so you don't have to do the 1 day or 2 day letter.
Yeah,
Uh,
well, on the other side, in NABOR, if you do nothing at the end of the finance contingency, it just keeps going. Nothing happens.
yeah.
But in FAR, if you do nothing, you lose the contingency. It expires. So you
This
better do something if you're not going to get this loan. If you haven't gotten loan approval or if you got denied, everything needs to happen during your term. And in this case, you've got everything else is kind of the same. So again, you've got your financing versus cash.
prevailing is the default interest rate, so if you don't put a number in, you
Yeah,
really
which is fine. I think that's a good compromise for buyer and seller, whatever the prevailing rate is, and that would be here. You'd put that, you'd choose what kind of loan. What kind of loan is very relevant. If you chose conventional and then the buyer went and tried to get an FHA but got denied for it, they wouldn't be protected under this financing contingency.
And that's the case
Fixed.
I was talking about, Christian. It dealt with this type of contract. If you
Yep.
apply for something different, then you don't get the benefit of the financing contingency.
Yep. So you got the prevailing rate, like you talked about. You've got your 30-year versus a 15-year loan term. And then it actually spells this one out much clearer. Buyer's mortgage broker or lender having received an appraisal or alternative valuation of the property satisfactory to the lender, if either is required by a lender, which is sufficient to meet the terms required for a lender to provide financing a buyer proceed to closing. So in this case, Dad, you've got a lot more ammunition to kind of back up your position that as long as it's good enough to give this loan, it meets the requirements of the financing contingency.
Right.
So if on our scenario, if it only appraises for 900, but the lender would still give them the exact same loan, the buyer doesn't have the right to terminate under this contract. And
NABOR is silent unless you use the
NABOR
addendum.
silent, right, unless you use the appraisal. So it may be the best scenario is if you're going to go that route, the best scenario is to include an appraisal contingency in both, even though that drives me crazy. I hate that. I like less forms, but maybe I lost that one. Um, let's see here.
This is actually a very complicated paragraph.
This is incredibly complicated. It does again have the what good faith effort is. So buyer shall keep seller and broker fully informed about the status of buyer's mortgage loan application. Buyer authorizes buyer's mortgage broker, lender, and closing agent to disclose such status in progress and release preliminary and finally executed closing disclosures to seller and broker. It's right in there. I didn't go over that with NABOR, but there's something similar, I believe. Maybe it's silent to that.
This one, if you do nothing within the loan approval period, the buyer is giving up certain rights. So
let's look at that. Number 3. So if within the loan approval period, so by default, it's 30 days. NABOR's default was 45. Buyer obtains loan approval. Buyer shall notify seller the same in writing prior to the expiration, or if buyer is unable to obtain loan approval within the loan approval period, but buyer is satisfied with buyer's ability to obtain, buyer shall deliver written notice to seller confirming the same. So they're basically saying if your buyer's moving forward, either because the loan was approved or because they're willing to move forward, just let the seller know, hey, financing's all good to go. We'll see you at closing.
I tell people the buyer should write some sort of letter. There should be some sort of email within the loan approval period. Otherwise, the seller has the right to terminate for a certain number of days after the loan approval period. So it's almost malpractice if you don't. I tell people, put it on your calendar 7 days before the expiration of the loan approval period, and let's talk about the 3 options the buyer has.
Yep.
And they got to do something. They can't just sit
I think
there
that's good advice. So then we've got 4, buyers unable to obtain loan approval or cannot timely meet the terms of loan approval, all after the exercise of good faith effort. Buyer may terminate this contract by delivering written notice of termination to seller prior to the expiration. Provided buyer is not in default under the terms, buyer shall be refunded the deposit. So it's a lot more clear to a buyer that they would get their money back. Number 5 here, if buyer fails to timely deliver written notice provided above to seller prior to expiration, the buyer shall proceed forward this contract as though paragraph 8 above had been checked. So which the cash. So basically you lose your contingency at that point.
It automatically waives.
Automatically. It doesn't just keep going. You lose it. Use it or lose it, right?
You really have to know this, or you could look really bad with your
you could look really bad. It's quite different. You've got all the different scenarios that are in play there they're a little trickier. So you just have to be careful with this stuff. Beyond that, the big thing that the next big thing I wanted to point to was not all loans are created equal. If you've got a buyer that's borrowing money from a brokerage account or from a home equity line on another property, that's not really the right form to use. You don't use the financing contingency in those scenarios. I did this deal 2 ways yesterday. In one way, we just did a longer as-is contract. So we said, give me 15 days. I'll make sure my home equity line is ready to go. If it's not, or if the inspection is wrong or something happens, I'll just get out. I don't need any financing contingency. The alternative was we added language to other terms and conditions that said, in the event buyer is denied for their home equity line for the property located at blank, for any reason, buyer may terminate and receive the deposit in full. So we created like a home equity line contingency. And then for the other buyer, we just had an extended as-is contract. I like the as-is. It's a lot simpler for a buyer, but We did
Yeah.
the contingency. We had to balance. What does the seller require? What does the buyer want?
One practical thing I always give my buyers is have backup money. I mean, because banks are, they make mistakes or they don't necessarily deliver. The person you're dealing with initially is essentially a salesperson who's going to put their best foot forward. So, I'm a belts and suspenders kind of person. If the bank is not ready to deliver, I don't want to lose my deposit. I don't want to lose a deal. I want to have, I want to be able to borrow from my 401k or my Uncle Fred or whatever it is.
It's really tricky because if your backup is I'll just sell my stocks and I'll pay cash, you don't want to do that and incur the tax
Capital gains.
liability if you don't actually need it. So what I would even suggest if you really think this loan is going to happen, then you need to release the deposit and get an extension. So you say, look, I'll release the deposit, give me another week to double check because I don't want to take on, if you're selling $1 million in stock and taking on a $200,000 tax liability, that's not worth it. Just, give up the $50,000 deposit in that scenario. Just walk away. Or let's negotiate an extension that benefits the seller and gives the buyer the chance they need to get financing lined up. Who you use is really, really important. There are a number of lenders we work with that we know will get the deal done, and there are others that we are afraid the whole way through.
The out-of-state ones don't return our phone calls, so we have no clue what's going on. On the release of the funds, Christian, I tell sellers if they need one more week to close, give them two, but condition it upon them waiving the financing contingency and releasing the deposit to the seller. That way you don't have a big, messy, expensive fight over the deposit. And the realtor should try to get some or all of their commission from that deposit if it's a big number. So we're trying to look out for the realtors as well.
Yeah,
And that comes up. I had that at least once a year. I mean, it's amazing. Oh, they're guaranteed they'll get it in a week. Give them 2 weeks, then they have no reason why they won't release the money.
I agree. Awesome. Well, thank you everybody for coming. Hopefully you learned more than you ever wanted to know about the financing contingency.
Paragraph 8's tough.
You can delete this from your memory here on out. But if something comes up, if you need us, you're not as familiar with these loans, just call us. We work on this every day, even if we don't want to. And so just give us a call. All right. Thank you, Dad. I appreciate it. See you, everybody.